So, hey everyone, welcome back to my channel Legalize Hub. I'm Kanak Shukla, and this is the ninth lecture in the series of Law of Tort. So, today we are going to cover the topic assault. So, this is basically the table of contents, and these are the topics which I am going to cover in my today's video. So, these are what is assault, difference between assault, battery, and mayhem, essential elements of assault, important case law, and some illustrations related to this topic. So let's begin with our first topic, that is assault. What is assault? In common law, assault is a tort, an act of the defendant which causes to the plaintiff reasonable apprehension of the infliction of a battery on him by the defendant. In simple words, when the defendant creates by his act an apprehension in the mind of the plaintiff that he is going to commit battery against the plaintiff, the wrong of assault is completed. So basically, assault means when someone just creates an apprehension in the mind of the other person, that may be plaintiff or someone else, that that the defendant or any other person is going to commit the battery. What is battery? That is the actual use of physical force on that particular person, and that person who just creates the apprehension in the mind of the plaintiff with the intention he that he or she is threatening the other person to deliver any property or to deliver anything which is precious for the other person. So this will amount to the assault, and the defendant or the other person who uses the assault to get the possession of that particular property or thing or goods will be held liable in the court for the wrong of assault. So, in simple words, let's take an example that person A is having a gun, and the person B is standing in front of him. Person A is saying, just give me your property, otherwise I will shoot you. And he is pointing the gun towards the person B. So, because of the apprehension that person A creates in the mind of person B, that he is going to use that gun to shoot him if he will not deliver his property. So this will amount to assault, because of that particular fear person B delivers his property. So this will amount to assault, and person A will be held liable for the assault, and he will be liable to pay compensation to person B for using the assault. So the wrong of assault consists of an attempt to do harm rather than the harm being caused thereby. So basically, wrong of assault is only the attempt to do harm, that is, only the attempt to use a physical force. There is no actual use of any physical force here. In simple words, assault means fear of use of force against someone. So basically, someone will be held liable for the assault when that particular person creates the fear in the mind of other person that he and she is going to use that particular force against the other person to get the possession of particular property or good. One can be guilty of assault even if he or she did not physically harm the victim. So as we discussed that in assault there is no actual use of force, so the person can be held liable or guilty of assault even he or she did not use any physical force. If there is no use of physical force during the act, still that person can be held liable for the assault, because as we discussed earlier, in assault there is no use of actual force. So I hope what is assault, that particular topic is clear to you all. So let's move forward to our next topic, that is difference between assault, battery, and mayhem. So these three topics are totally different from each other. So let's discuss each one of them. Assault means fear of use of force. Battery means actual use of force, and mayhem means when one body part is so severely injured that it means to be replaced. So, as we discussed, assault basically means when there is a creation of fear in the mind of other person of use of force against that particular person. But battery is just opposite, when that particular person, after creating fear in the mind of other person, also uses the actual force against that particular person. So this will amount to battery. And mayhem means when any person who creates an apprehension in the mind of other person that he or she is going to use the physical force, and he or she also uses the physical force, and because of his or her physical force, any body part of the defendant is severely injured, that is means to be replaced. So this will be known as mayhem. Okay, so let's take an example. एक person A and person B है. Person A and B are friends. Person B is wearing a watch. तो पर्सन ए क्या बोलता है बी से कि अपनी वॉच मेरे को दे दो, तो पर्सन बी बोलता है कि नहीं ये मेरी वॉच है, मैं तुम्हें क्यों दूं। तो पर्सन ए जो होता है वो क्या करता है, एक उसके पास स्टिक होती है, वो निकालता है और बी की तरफ पॉइंट आउट करता है कि अगर तुमने मुझे अपनी वॉच नहीं दी तो मैं स्टिक से तुमको मारूंगा और तुम्हारी वॉच ले लूंगा। तो पर्सन बी तभी क्या करता है, तो यहाँ पे क्या हुआ कि वो असॉल्ट हो गया अगर वो फिजिकल फोर्स नहीं यूज करता और अगर बी वॉच दे देता है, तो दिस विल अमाउंट टू असॉल्ट। लेट्स टेक अ सेकंड सिनेरियो। यहाँ तक उसने उसके माइंड में फियर क्रिएट कर दिया, बिकॉज ऑफ विच पर्सन बी ने फिर भी बोला कि नहीं मैं नहीं दूंगा अपनी वॉच, तुम कुछ भी कर लो। तो पर्सन ए ने क्या करा, स्टिक से उसको मारा। तो यहाँ पे क्या हो गया, ये बैटरी हो गया, बिकॉज आफ्टर क्रिएटिंग अ फियर इन द माइंड ऑफ पर्सन ए ऑल्सो यूजेस द स्टिक to hit him. So there is a use of physical force. So this will amount to battery. But वो उसने उसे तब तक मारा पर्सन बी को, पर्सन ए ने, जब तक उसका राइट हैंड जिसमें पर्सन बी ने वॉच वेयर कर रखी थी वो इंजर्ड नहीं हुआ, सेवरली इंजर्ड नहीं हुआ कि अब उसे रिप्लेस कराना पड़े। सो दिस विल अमाउंट टू मेहम बिकॉज ही सेवरली इंजर्ड द hand of person B that it means to be replaced. So this will amount to mayhem. I hope with this example the difference between three of them is clear to all my legalites out there. So let's move forward to our next topic, that is essential elements of assault. So basically there are three essential elements of assault. First is intentional attempt or threat to cause injury. Second, second is ability to cause harm. And third is must create a reasonable apprehension of bodily injury. So the first essential basically says that there must be an intention of that particular person who is creating the apprehension in the mind of the other person to use the physical force against that particular person. मतलब उस person का intention होना चाहिए कि वो fear create करे other person के mind में कि वो physical force use करेगा. Second essential is ability to cause harm. That particular person is able to cause harm to the plaintiff, having the intention to cause harm. That particular person is also having the ability to cause harm. And the third intent must create a reasonable apprehension of bodily injury. That means that particular person must create a fear in the mind of the other person, that there will be a reasonable apprehension of bodily injury. मतलब कि अगर उसने वो प्रॉपर्टी या गुड्स या जो भी वो पर्सन डिमांड कर रहा है प्लेंटिफ से वो नहीं किया, तो वो क्या करेगा, फिजिकल फोर्स यूज करके बॉडली इंजरी पहुंचाएगा उस पर्टिकुलर पर्सन को. Okay, so there are basically three essentials. First is there must be intention, second is there must be ability to cause harm, and third is must create a reasonable apprehension of bodily injury. So I hope the essentials are clear. So let's move forward to our next topic, that is important case law. So the case law is Brown versus Candle, 1850. Case facts are that is George Brown, that is plaintiff, and the George Candle, that is defendant, both own dogs. One day their dogs begin to fight each other. Candle took a long stick and began hitting the dogs to separate them. Brown watched from he thought was a safe distance, but the dogs moved in his direction, causing Brown to move away from them towards Candle's back. Candle did not see Brown move. Candle raised his stick again and on his back swing inadvertently hit Brown in the eye. Candle severely injured Brown. Brown sued Candle for assault and battery. So basically case facts ये है कि जॉर्ज ब्राउन एंड जॉर्ज कैंडल दे बोथ आर फ्रेंड्स, और इन दोनों के पास ही डॉग था, इन दोनों के पास ही डॉग्स थे. एक दिन क्या होता है, दोनों के डॉग्स फाइट करना स्टार्ट कर देते हैं, तो जो कैंडल होता है वो लॉन्ग स्टिक से उन्हें हिट करना चालू करता है, जिससे वो एक दूसरे से सेपरेट हो जाए और फाइट करना बंद कर दे. जो ब्राउन होता है वो ये समझ करके कि एक सेफ डिस्टेंस है वहां से ये सारी चीजें देख रहा होता है, बट क्या होता है जो डॉग्स होते हैं वो वो क्या करते हैं, वो ब्राउन की डायरेक्शन में मूव करने लग जाते हैं जिस डायरेक्शन में ब्राउन खड़ा हुआ था। बट जो ब्राउन होता है वो खुद को बचाने के लिए उन डॉग से जो कैंडल होता है उसके बैक साइड में जाकर के खड़ा हो जाता है। जो कैंडल होता है वो ये देख नहीं पाता कि ब्राउन उसके पीछे खड़ा हो गया, और वो स्टिक ऐसे बैक साइड को मूव करता है डॉग्स को फिर से हिट करने के लिए, और वो ये देख क्योंकि उसे पता नहीं होता है कि ब्राउन पीछे खड़ा हुआ है, और वो स्टिक ब्राउन की आई में जाकर के लग जाती है। तो अब यहाँ पे जो ब्राउन की आई होती है वो सेवरली इंजर्ड हो जाती है। तो ब्राउन क्या करता है, कैंडल के अगेंस्ट असॉल्ट एंड बैटरी का केस ले आता है। So the court judgment, so the court held that this will not amount to assault and battery. Rather, the defendant will be protected under the exception of inevitable accident. Therefore, the plaintiff will not get compensation for the injuries he suffered, and the defendant cannot be held liable for assault and battery. तो कोर्ट ने ये जजमेंट दिया कि जो कैंडल होगा वो ना ही असॉल्ट के लिए लायबल होगा ना ही बैटरी के लिए, क्योंकि ये जो पूरा इंसिडेंट है वो इनएविटेबल एक्सीडेंट के अंडर कवर होगा, बिकॉज ये जो पूरा इंसिडेंट हुआ वो इनएविटेबल था, अनएक्सपेक्टेड था एंड सडन था। दोनों तरफ से कोई भी एक्सपेक्टेशंस नहीं थी या कोई भी इवेंट फोरसीन नहीं था और ना ही प्लान था। ये क्या हो जाएगा, इनएविटेबल एक्सीडेंट हो जाएगा, जो कि एक सडन एक्सीडेंट और इंसिडेंट है। और अगर हम एसेंशियल्स पे जाए तो फर्स्ट क्या था, देयर मस्ट बी एन इंटेंशन। तो क्या कैंडल का इंटेंशन था कि वो उसको हिट करे ब्राउन को? नहीं था, क्योंकि कैंडल को ये पता ही नहीं था, ये अचानक से हो गया, बाय मिस्टेक हुआ, क्योंकि कैंडल को ये नॉलेज नहीं थी कि पीछे ब्राउन खड़ा हुआ है, अदरवाइज वो ये नहीं करता। So here the candle will not be held liable for the assault and battery. So let's move towards our last topic of this video. So that is illustration. So first illustration is B shows a sword to C and says that he was thinking of sharpening it for using it in future. This would not amount to assault as there was no direct intention to use it against C. तो बी एक कोई पर्सन था जो स्वॉर्ड ले रखा था, उसने सी से बोला कि मैं इसको शार्पन कराने का सोच रहा हूँ फॉर द फ्यूचर यूज। तो सी को ये लगा कि सी ने क्या बोला कि ये असॉल्ट हो गया क्योंकि यहाँ पे फियर क्रिएट हो गया, बट दिस विल नॉट अमाउंट टू असॉल्ट बिकॉज देयर इज नो इंटेंशन, देयर इज नो एबिलिटी टू हार्म एंड देयर इज नो रीजनेबल एप्रीहेंशन in the mind of the other person to cause bodily injury. Second illustration is A show a gun point that he would use it against D if he did not. So there is a correction. It's not ID. It's if he did not. If he did not bring him 10,000 the next day, this will amount to assault as A directly said that he would use the gun to shoot D. तो यहाँ पे एक पर्सन होता है जो गन पॉइंट आउट करता है डी की तरफ, और वो ये बोलता है कि अगर डी नेक्स्ट डे तक 10,000 रुपीज नहीं लेके आता है तो वो शूट कर देगा ए को। So this will amount to assault because it is a creation of reasonable apprehension of use of causing bodily injury to the D. So this will amount to assault. So the third illustration is P says to R that I will bang his head on the wall and will repeat it until he dies. While saying this, he was in anger and also showing his fist to R. This amounts to assault. तो द थर्ड इलस्ट्रेशन सेज दैट कि कोई पी पर्सन होता है वो आज से ये कहता है कि मैं तब तक तुम्हारा जो हेड है वो बैंग करता रहूंगा वॉल पे जब तक तुम्हारी डेथ नहीं हो जाती या तुम मर नहीं जाते। तो और ये जब वो बोल रहा था पर्सन पी तो वो बहुत ही ज्यादा गुस्से में था। So this will amount to assault because he creates a fear in the mind of R that he is going to kill him. So this will amount to assault and P will be held liable for this. Last illustration is that is fourth. F and G are good friends. F says while joking that he will slap him if he does not take his medicines. This will not amount to assault. तो F और G एक गुड फ्रेंड्स होते हैं। F ने मजाक मजाक में G को बोला अगर तुम अपनी मेडिसिन नहीं लोगे तो फिर मैं तुम्हें चाटा मार दूंगा। So this will not amount to assault because as they are good friends and he while joking said that because he is not having any intention to slap him. So this will not amount to assault. So that's all for today. I hope All the legalites are out there are liking my videos. And yeah, guys, don't forget to like, share, and subscribe to my channel. And also, please press the bell icon so that whenever I will upload a new video in the series of Law of Thoughts, so you will get a notification of it. And yeah, keep loving and keep supporting. And thanks for watching.